Judge, may I open court?
Yes, please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1443. Charles Erwin, petitioner versus Federal Aviation Administration. Mr. Burns for the petitioner, Ms. Gardner for the respondent.
Mr. Burns, good morning.
Good morning. Can you hear me okay, Your Honor?
Yes.
Very good. Are you ready for me to commence?
Yes, please proceed.
May it please the court, Joshua Burns of Crow and Dunlevy for the petitioner, Charles Clay Erwin. In 2016, Mr. Erwin was diagnosed with alcohol use disorder. Following treatment, the FAA issued Mr. Erwin an authorization for special issuance, which allowed Mr. Erwin to return to work as a pilot, but which required Mr. Erwin to abstain from alcohol completely. The authorization worked exactly as it was supposed to, in that it balanced the livelihood of an airman with the need for public safety. Mr. Erwin held up his end of the bargain in this situation. He has been abstinent from alcohol for nearly 5 years. His last drink was in November of 2016. Mr. Erwin's only mistake in this situation, if you can call it a mistake, was eating pulled pork that, unbeknownst to him, was cooked in beer. Contrary to the recommendation of its own retained expert, the FAA withdrew Mr. Erwin's authorization. It did so without substantial evidence, and Mr. Erwin respectfully requests that this court reverse that decision.
Mr. Burns, let me ask you, can a pilot with a diagnosed substance dependence ever get an unrestricted medical certificate? You must think he is able to, or you wouldn't have brought your lawsuit, but I couldn't find an answer to that in any of the regs or anything else we looked at. And I'm going to ask the FAA lawyer the same question.
And I believe the answer, according to the FAA regs, is yes, Your Honor, because if we're looking at, bear with me for one moment while I get to the FAA's brief in this action. It actually cites to a regulation that indicates that following that they must essentially remain on a restricted certificate for a period of 2 years. I'm looking at page 5 through 6 of the FAA's brief in this action. It says an established medical history, this is citing to 14 CFR section 67.101, which indicates that where there is an established history or clinical diagnosis of substance dependence, that is a situation where a restricted authorization should be issued. However, it can be made into a fulsome authorization upon a total abstinence from the substances for not less than the preceding 2 years.
Well, now, what about this lifetime monitoring?
That is, as I understand it, a proposed newly instituted FAA requirement that for people that are on a special issuance, they would essentially, at this point in time, would essentially remain on monitoring for the rest of their life. Now,
but they still could get an unrestricted medical certificate?
I believe that's a question for the FAA, but
what's your understanding?
My understanding is that they would have an otherwise unrestricted authorization, except for the fact that they would still be subjected to monitoring testing requirements, essentially. Okay. So I guess in that world, it would not be a fully unrestricted authorization. It would still be subject to an ongoing monitoring requirement. But again, I believe this is proposed rulemaking. I'm not sure if these rules are in place at this point in time. So I am speculating a little bit about what the FAA has done or intends to do with respect to lifetime monitoring.
All right, thank you. I'll ask Ms. Gardner.
Thank you. So the most—
Mr. Burns,
Yes, sir.
I have two questions. What's exactly the remedy you want from us? Because I ask because the first authorization expired in 2020. right? And that's the one we're reviewing. We're reviewing the FAA's withdrawal of the first authorization.
That's correct.
Okay, now that's expired.
Well, it
So-
would have expired if it had still been in place. Yes, Your Honor.
Well, but so what's the remedy you want? What do you
We
want
would
from
like
us?
the court to determine that the revocation, the withdrawal of the initial authorization was improper, that it was arbitrary and capricious. And
Okay, and then what will the FAA, what will the agency, if we do that, what will it have to do?
well,
What
I
will it
believe
do?
that
What
we
will
have
you
to-
ask it to do? Let me ask you that way.
we would ask the FAA at that point to evaluate Mr. Erwin's application as though he were coming off of a special issuance authorization in 2020 and to
I see.
consider him
I
for
see.
an unrestricted authorization.
All right, second question is this.
Yes, sir.
So for Mr. Erwin to be eligible for an unrestricted certificate, 107A4 requires established clinical evidence of recovery, including sustained total abstinence from alcohol for not less than the preceding 2 years.
Yes, sir.
Now, did that evidence exist in the record at the time Barry wrote his letter?
At the time, what Your Honor,
Barry, at the time that the surgeon, Barry, is that his name? Is that who?
the
It's
federal
been- is it-
Sago,
Yeah.
wasn't it?
No, the Barry letter, the letter we're reviewing. Do I have
Yes,
the wrong-
Oh, the air surgeon. Yeah.
The air surgeon's letter. Did that evidence, was there evidence in the record at the time he wrote that letter that you believe supports both of those?
I believe it does, Your Honor. I believe that the period of time between when Mr. Erwin began his period of abstinence and when that authorization, or I'm sorry, that withdrawal of the authorization in September of 2020 occurred, he had maintained his sobriety for almost 4 years at that point in time. Now that we're before this court, it's been almost 5 years of total abstinence that we believe the evidence universally and unilaterally supports the proposition that he has maintained his abstinence for that entire period of time. So yes, I believe he would satisfy the requirements for an unrestricted authorization at that point in time as of either September 2020 when that letter was issued or as of May 2020 when I believe his initial authorization would have expired had it still been in place up until that time.
I guess, counsel, I'm still not sure that I understand your answer to Judge Tatel's question and Judge Henderson's question. What difference does it make if we deny your petition? Because today your client can apply for an unrestricted certificate, right?
Well, I don't believe he can today because he is currently on a new special issuance certificate that does not expire until some point farther into the future. So he would only be entitled to apply for that, as I understand it, when his current certificate expires. And so, and additionally, there are consequences just to the withdrawal of the certificate here. I mean, he was put on a last chance contract with his employer that could likely be undone. It was based purely on the fact that the FAA had made a determination that they needed to withdraw his authorization due to a positive test. If we reverse that decision, he has the opportunity to essentially undo that contract, void that contract with his employer, which is a very draconian remedy here. And fundamentally, Your Honor, he has the right to clear his name. He was unlawfully accused of violating the terms of his certificate with the FAA, and it besmirched his reputation. He has the opportunity to reverse that decision, which was based on a complete lack of evidence. It was arbitrary and capricious to the highest degree, and he has the right to remedy that.
Aviation Act and sometimes by the Administrative Procedure Act. But I didn't necessarily see in your briefing how our standard of review would be different as to these issues under the APA versus the FAA. And did I miss that?
No, I believe that's correct, Your Honor. I think we're dealing with an arbitrary and capricious and substantial evidence standard in either circumstance, Your Honor.
I mean, given that very deferential standard, whereby even if we thought that maybe the FAA did not have, maybe we would decide it differently, or maybe we would feel like the preponderance of evidence were on your side. If there were substantial evidence, we would still have to deny your petition. So given that, what's your argument for how you meet that standard of review?
Your Honor, I see that my time has expired. Is it all right if I proceed?
Go ahead and answer. Yes.
Well, the only evidence in this case that supports the proposition that Mr. Erwin did not maintain his abstinence is the positive test. And if we're talking about a scientific organization like the Federal Air Surgeon branch of the FAA, they're required to abide by scientific standards in doing that. In responding to our brief and their response, the FAA attached an appendix which included several articles that universally, I mean, first of all, those were not part of the record that was before the Federal Air Surgeon, but so we don't believe that those are actually properly before this court. But those articles recognize the fact that the FAA cannot apply this positive test alone as a basis to have actions taken against Mr. Erwin with respect to his livelihood. First of all, those articles say that the threshold should be set much at 200 or 250 nanograms per milliliter in order to avoid the risk of exogenous exposure, which is exactly what happened here. And second of all, those articles indicate that the decision maker should be taking, if there is a positive test, the decision maker should be taking into consideration all of the clinical evidence, and all of that clinical evidence, that meaning what Mr. Erwin said, what the factual evidence indicated, all of that universally points to the fact that Mr. Erwin maintained his abstinence and abided by the terms of his authorization, which only required him to maintain his abstinence and to subject himself to random testing, both of which he did. A positive test by itself is not a basis for saying that he violated his authorization. Thank you, Your Honors. I will certainly answer any additional questions, though I know that I'm well out of time.
All right. Ms. Gardner. Ms. Gardner?
Yes, good morning, Your Honor.
Go ahead.
Good morning. May it please the court, Casey Gardner on behalf of the FAA. This case is about a commercial airline pilot with a diagnosis of alcohol use disorder who tested positive on a random alcohol test. In light of that test, the FAA withdrew his discretionary authorization that had been issued to him that exempted him from the FAA's medical standards, which he does not meet by virtue of his clinical diagnosis. So what we're talking about here today is not your regular standard run-of-the-mill medical certificate. It's an exemption from the regulations that was issued to Mr. Erwin by the Federal Air Surgeon. And accordingly, his authorization is only valid to the extent that he complies with its conditions, because those are the conditions that the Federal Air Surgeon, in the exercise of his aeromedical judgment, those are the conditions that allow Mr. Erwin to fly passengers without endangering public safety. And as soon as he fails to comply with those conditions, his authorization can be withdrawn. And that's what happened here. In January of 2019, the FAA received a report from Mr. Erwin's sponsoring aviation medical examiner stating that he had tested positive on an alcohol test. That information showed to the Federal Air Surgeon that Mr. Erwin had failed to comply with the terms of his authorization, and that he had an adverse change in his medical condition, namely that he was no longer in stable recovery from his alcohol disorder. Upon that information, the FAA withdrew his authorization, and in furtherance of the FAA's safety mandate, we would not be doing our duty to the flying public if we allowed—
Ms. Gardner, Mr. Erwin is challenging that very positive drug test. That's his whole case. Here, let me take a second and describe for you my concern here, and maybe you can explain to me why I shouldn't be concerned, okay? So we're reviewing one document, the Berry letter, right? That's what we're reviewing. And it identifies two pieces of evidence. The positive alcohol test and his history of alcohol dependence, those two things, right? Those are the two things in the Berry letter. So as I look at the record, Erwin introduced quite a bit of evidence challenging both of these. And let me just mention a couple of them here. Unrebutted evidence that he accidentally ate food cooked in beer shortly before the test. Test results that came back negative on hair and nail samples just taken one day after that test. Literature showing that testing of this kind have a propensity for false positives. And finally, the report from a forensic toxicologist that the Erwin's positive test results are more consistent with accidental exposure to ethanol. So, all right, so those are his major things. Now I look at the Berry letter and I see no response to any of that. I don't see any response to that, even though the regulation under which you're operating, I'm looking at 401I, says that that someone who has their authorization withdrawn has a right to have the air surgeon not only review it, but his supporting medical evidence. He has to review, quote, his supporting medical evidence. So given the fact that Erwin has submitted extensive evidence to counter the major finding of Dr. Berry, and that Dr. Berry didn't respond to any of that, how can we sustain this?
Well, what we have is a positive test certified by a laboratory, and the FA's position is that.
I'm sorry to interrupt you, but he challenges that. He has at least four pieces of evidence to suggest that was a false positive. And it still may be that, it may well be that his evidence is not convincing. But but Dr. Berry didn't consider it, at least not in his letter.
Well,
given that, I just don't see how we can sustain it. The agency's own regulation says he has a right to have his, quote, supporting evidence reviewed. That's what it says. I'm reading you from your regulation, supporting medical evidence. You know about that, right? Yeah.
Yes, Your Honor, that is what the regulation says. And Dr. Berry's letter does state that he reviewed the entirety of Mr. Erwin's airman medical file, and he also considered the additional information that he supplied. But this
is an arbitrary and capricious case, right? You agree with that? I mean, we're applying the pretty standard, and an agency can't. I know of no case that says an agency can satisfy its burden under any of these statutes, APA or whatever, by simply saying I considered the petitioner's evidence and found it without merit. We don't even do that. We can't do that. And I certainly don't see how a federal agency can do that.
Well, what we have here is a positive alcohol test from an airman with a history of alcohol use. We rarely, if ever, don't have pilots who test positive, who don't come back to us with explanations for why it occurred. I mean, people are not always truthful with the FAA, and their livelihoods are on the line. We understand that. So that's why we require random unannounced tests. I mean, there's a reason we have.
No, Miss, I'm not questioning the testing. That's fine. I'm glad, as somebody who flies on airplanes, I'm really glad the agency does do random testing. But this case is about whether the results of that random test are accurate enough to remove his authorization to fraud. That's what the case is about.
Sure.
And it's a pretty standard administrative procedures case. You know, the agency has made a fact finding. That fact finding has been challenged, and there's no evidence in the letter that the decision maker considered the evidence. That's kind of, you know, black letter law, administrative law.
And add to that the history from our court telling you in the Friedman case, which came up to us twice, you may be right, but you've got to support it.
Right.
Sure, and we did consider the information that Mr. Erwin submitted. I mean, his own
Where
forensic.
could you show us where that was done? Show us right. Where was that evidence considered? Give me something in the record. Let's look at the Berry letter, for example. That's it. It's got to be in the Berry letter, right?
Sure, and I do understand your concern, Your Honor. The letter says, I reviewed your agency medical file and the additional documentation you submitted in support of your request for review. So Dr. Berry is affirmatively stating in that sentence that he reviewed everything Mr. Erwin submitted.
But you understand my concern about that, right? I mean, how can we review that unless he tells us, for example, I mean, here, I'll give you an example. This Dr. Berry, he says, I reviewed the evidence, right? But he doesn't say why Erwin's evidence that the positive test came from eating food that had been cooked in beer. He doesn't explain. He doesn't explain why he's rejecting that argument. He doesn't explain at all why he's rejecting the hair and nail sample evidence that Berry supplied. He doesn't tell us what's wrong with that evidence, and he doesn't explain why the report from the forensic toxicologist is wrong. Now, they all may be wrong, as Judge Henderson just said. There may be good reasons for rejecting every one of those, but they're not in the Berry law.
I understand your concern that the letter could have been more robust, but I think here the federal air surgeon's position is that we are entitled to rely on an objective, positive test to make a safety decision. And you know, even Mr. Erwin's own forensic toxicology report that he submitted for us to consider says that this particular value, this numerical value, could be indicative of previous heavy drinking 1 to 3 days before the test, previous light drinking 12 to 36 hours before the test. I mean, those are rational.
Is that in the Berry letter?
No, Your Honor, it is not. No, ultimately what's in the Berry letter is the fact that he tested positive and that's contrary to the express terms and conditions of his authorization. I mean. Okay,
well, thank you. I take your argument.
I appreciate that.
All
I
right.
see that my time is
I
up.
have one question, Ms. Gardner, and that is, if we were to remand along the lines as we did in Friedman, and let's say you all became convinced that you should have granted the motion for reconsideration of the withdrawal, would you vacate that withdrawal? And I'm asking the question, and the reason I'm asking the question is, if Mr. Erwin wins this case, his vacated withdrawal remains on his record. Is that correct? That is, as vacated. It isn't erased from his record.
I'm not entirely sure procedurally what would happen here. I mean, hypothetically, if we were to reverse the withdrawal at this juncture, I mean, his original 2017 authorization is expired. And what would have happened upon the expiration of his authorization is that his medical qualifications would have been reviewed and reevaluated to determine what, if any, modifications to his authorization were necessary at that juncture. And that is actually precisely what occurred here. We did review all of the additional information. We reviewed his discharge records and also his.
Okay, here's my concern. If, let's say, as a lawyer, a complaint is filed against me and it is eventually thrown out, it depends on the state law, but that record, my record, still shows a complaint against me that was dismissed. And that's my question. If this withdrawal is vacated, do you know, you may not know, what is reflected on Mr. Erwin's record?
The short answer is I don't know. Procedurally, we obviously disagree that should be the case, but we could always write a new letter withdrawing our previous reversal, so to speak. But there isn't really, given the procedural informal nature of this, there isn't really a case file. There's just an airman medical file on file with the FAA that contains the entirety of his history with the FAA. So it would contain probably both the original withdrawal letter and our subsequent decision.
All right, thank you. If there are no more questions, Mr. Burns, why don't you take 2 minutes?
Thank you, Your Honor. I would just like to address really one of the points that was raised there, which is the idea that the FAA is allowed to rely on a positive test. I don't disagree that the FAA can use that as a starting point, but their own literature suggests that it is not the end point for this analysis. All basically of the articles that they submitted in their appendix recognize the risk of exogenous exposure, and through food in particular. And as a result of this, the literature that they cite recommends a threshold of 200 nanograms per milliliter or 250 nanograms per milliliter. Mr. Erwin had a negative test at those levels. The El Rashid article in particular notes that, quote, legal or disciplinary action based solely on a positive ETG test is inappropriate and scientifically unsupportable at this time. The Jatlow article suggests using a 200 nanogram per milliliter cutoff would, quote, reduce risk of interference from extraneous exposures. And as a result, they recommend those thresholds in a context where there are legal or livelihood ramifications. So the FAA's own cited authority rejects the proposition that the FAA can rely on this test, particularly when that is the sole basis that they're relying upon. You have to then take that and look at the context in which it occurs, the clinical history of the patient and what else you know about them. The Anderson-Streichert article says—
All right, we have all this evidence in the record. Thank you. Madam Clerk, if you'd call the next case.
Case number 20-5304, Judicial Watch, Inc., appellants versus United States Department of Justice. Mr. Orphanides for the appellant, Mr. Poulan for the appellate.
Mr. Orphanides, good morning.
Morning. May it please the court. Paul Orphanides for appellant Judicial Watch. When we filed the appeal and briefed this case, the court had not yet decided the Reporters Committee versus FBI case that we cited in our July 28J letter. In our view, that case confirms the requirements of the FOIA Improvements Act of 2016 that we spent a fair amount of time briefing. In our view, that the FOIA Improvements Act is a sea change in how deliberative process exemption B5 claims are to be handled. But really now, I think the question boils down to, do the agency declarations satisfy the FOIA Improvements Act standard as articulated in the Reporters Committee decision? And our view is they clearly do not, that what they are is more of the routine sort of assertions of deliberative process that predated the FOIA Improvements Act. So for example, well, first of all, there are 4 records, and these are drafts of either a decision or an instruction. So we don't even know if this is a decision, if these reflect like preliminary thoughts on about a decision, or if they're an instruction. The declarations use both terms. An instruction to department staff on not to enforce President Trump's executive order. So we have one draft that was sent in the morning. We have another draft that was sent in the early afternoon from, I guess, the time he would have been acting Deputy Attorney General Axelrod to acting Attorney General Yates. Then we have 2 drafts that acting Attorney General Yates sent to herself. We don't know who prepared these. We don't know when they were prepared. We don't know if they were solicited or unsolicited. We don't even know if they reflect the decision not to defend the executive order, or if they are simply instructions or explanations about that decision. What the agency...
Counsel, can you clarify, are you challenging both that the documents were not pre-decisional and not deliberative, or are you just challenging that they are not deliberative?
We challenge both. I think the harm, the shortcomings in the harm analysis of the declarations make it much more clear. I mean, the law requires that the agency show reasonable foreseeability that harm is going to result from the disclosure of these records. And because we don't know anything about them, except we know approximately the time frame. We know how the records flowed from the Deputy Attorney General to the Attorney General, and then she sent 2 of them to herself. That's all we know. The declarations use generic terms, working drafts, successive versions, multiple revisions made by department staff. Now that's really curious because, I mean, the last 2 documents themselves are, it would appear that to the extent they reflect any revisions, there would be the revisions of the Attorney General. And that's hardly staff. So I guess my point is that we really know so little about these documents that it's very difficult to make any kind of harm analysis about what harm would result to interests protected by the deliberative process privilege if they were to be released. We don't know if these are just editorial changes. We don't know if they reflect if draft 1 had one option and draft 2 had a second option. We don't know that. We don't know if draft 2 is just different because it made.
Well, if they did have 2 options, let's assume we knew that. That would be a pretty good argument that it's deliberative, wouldn't it?
I think it would. That's right. Yeah. But we don't know that.
Your point is you just don't know.
Right. That's right. And even if it's just one option, we don't know if it's changing happy to glad or adding commas or moving paragraphs or sentences around. And there's just no information from which the court can provide, can undertake any sort of harm analysis.
In the district court, I know we have a lot of case law, which we're trying to protect the district courts from having to plow through lots of contested documents. And so the district judges can rely on the declarations. But did you ever ask the district court here why don't you just look at the letters in camera?
I don't recall. There were 2 rounds of briefing. So there was an initial summary judgment motion and cross motion.
Yeah, I understand that. But you never asked for her to the district court, well, just please look at the documents. There's only 4 of them and they're each a half a page.
I don't believe so, but I can check that for rebuttal.
I mean, it seems sort of odd that we're trying to decide whether a document is deliberative that none of us have seen, and they're documents that we could all read in 2 minutes.
That's right.
And then we could avoid all of this trying to figure out what is in the documents and what isn't in the documents.
That's absolutely
This
right.
doesn't make any, it just doesn't make any sense to me.
It's a
Why would we do this? I don't get it. Think how much easier it would be for all the parties if you wouldn't need all the declarations. You wouldn't need anything. You just look at the documents.
This is the process that's in place, and then, especially with a very short document, perhaps it doesn't make sense, but that's where we are. So unless the court has any further questions, I'll reserve the rest of my time for rebuttal.
All right, Mr. Pullum.
Yes, thank you very much, Thomas Pullum, for the Appellee Department of Justice. Judicial Watch seeks access to 4 drafts of a document explaining one of the most serious decisions that an attorney general can make, the decision to decline to defend the legality of an executive order. As this court recently explained in the Reporters Committee case, proposed drafts of a non-final agency decision that are still undergoing review, debate, and editing are the type of deliberative work in progress that falls at the core of the deliberative process privilege.
So is it the government's position? I mean, it's interesting that you use that quote, because if you strip away from the Brinkman affidavits, all the conclusory language that doesn't relate to the documents, basically all we know is that these are drafts, right? That's what we know. They're drafts. And, if that's all you need to do to protect them under Exemption 5, then it's hard for me to imagine anything that wouldn't be protected. And also, you mentioned Reporters Committee. Well, the documents in Reporters Committee were drafts, and we ruled that wasn't sufficient to protect them. So, you see my point? That's what kind of worries me about this. It seems like as I said, basically what you've got is drafts, and drafts characterizing the document as a draft can't be enough to protect it under Exemption 5, particularly after the FOIA Improvement Act was passed. Do you disagree with any of that?
Well, I want to be clear. The FOIA Improvement Act does not affect the scope of the privilege. It may affect the ability of it does affect the ability of a government to withhold. But when we're just talking about privilege, it doesn't change the scope of that.
Your point's well taken. That's a good point. But just to answer the question, just under the standard Exemption 5 case law we have.
Please. So I think the best resource here is the Supreme Court's recent decision in the Sierra Club case that came out earlier this year. There, the court said that a draft is, by definition, a preliminary version of a piece of writing subject to feedback and change. And for that reason, the court said a draft document will typically be pre-decisional because something calling something a draft communicates that it's not yet final. And what we look at, what matters, the court said, is whether the document at issue communicates a policy on which the agency has settled, whether the agency treats the document as its final view.
I've read that case, but that case is about whether the document is pre-decisional. The argument was that even though it was sort of a draft, it was in effect final, pre-decisional. It wasn't about whether it was deliberative. There's no discussion. I didn't see any discussion in Sierra Club about whether it was deliberative. The whole question was responding to the Sierra Club's argument that the agency couldn't protect them under Exemption 5 because they were final. That's what that case is about. So I mean, the cases you have to deal with are cases like Machado and Dudley, where, those are typical cases. We found those documents were deliberative, but only after the government told us a whole lot about what was being deliberated. We knew who was doing the deliberating and where they were in the decision-making process. We don't know any of that.
Well, I think we do here.
What do we know about who these people are?
So the Supreme Court and this court have described a deliberative document as one that's used to help the agency
But you just
prepare
answered.
formula.
Don't please.
Well,
don't
I just think it's setting the stage.
Just don't.
Mr.
I would
Pullum.
appreciate it if you would not respond to a fact question with a citation to a Supreme Court case.
Certainly.
I just want to know. I'm trying to understand this case, and it would help me a whole lot if you would tell me where we have the kind of information here that we had in Dudman and these other cases. We don't know who wrote them. We don't know what was deliberative about them. We don't know whether the deliberation was over substance or style. We don't know any of that.
So there's two pages in the JA that I think are helpful here.
Let's look at that.
So we have JA 158,
Right.
describing the documents that they reflect successive versions of a draft. So they show the internal development of the department's final decision.
Okay, now let's stop it. Let's stop and talk about that sentence. Okay. Successive development, right. But successive development of what? I mean, it could be that the first draft had the paragraphs in a different order than the second draft. That wouldn't be deliberative, right?
I think it would be under this court's decisions in Dudman and
It would be?
Dudman and Russell talked about.
How would a lawyer who drafts who is recommending that the order of two paragraphs be switched, how would that person be chilled in his or her future advice to that superior?
I think to answer that question, we look at paragraph 77 in the joint appendix, which talks about how statements made by the Attorney General on these sensitive and significant issues are subject to multiple rounds of editing and revision with intense attention to matters of emphasis, phrasing, and tone. Because these statements set policy for a large department and inform the public about the actions and priorities of that department, the precise language chosen is a matter of great concern.
Yeah, so I hear you basically telling us that any draft of a document to the Attorney General is Exemption 5 material, right? That's your point.
If that draft has not been adopted as final, yes.
Well, of course not. Any draft to the Attorney General is deliberative, right?
I think if it involves the type of policy and editorial judgment that this court has recognized go into the deliberative process, then I think that's correct.
Well, here, will you look at, do you have the Yates letter there in front of you, the Yates letter? Let me just ask you a question or two about it. Okay. All right, let's look at the Yates. Let's take two examples, okay? So it begins with two sentences. One says the president signed the order, and then the second one says it's been challenged. Suppose an earlier draft of this, suppose that was just one sentence. In other words, suppose the sentence had said, the president's order has now been challenged in more than one jurisdiction. In other words, the lawyer in the Attorney General office was saying to the Attorney General, this would read better if it was two sentences instead of one sentence. Is that deliberative?
So I think so. If it goes to the,
but why?
I think because in this context, as the declaration says, matters of emphasis, phrasing, and tone are so important. Now it may be.
But how about this one that I just asked you about? I mean, the problem, and this isn't your fault. I don't mean to be critical of you're dealing with a bunch of declarations here that make generic statements, and I understand that. That's sort of the problem here. But the question is, we have to decide about these documents, which we can't see. And I'm just asking you as a hypothetical, how determining whether this should be two sentences rather than one could possibly implicate the values underlying Exemption 5.
Well, I think there might be a difference between, say, a standalone suggestion that says, this should be one sentence as opposed to two, instead of a series of full drafts where we see the whole thing with all of these changes to specific wording that the declaration says are so important because of what they communicate to the public.
I can definitely, you're totally right about that. I can definitely imagine changing something from one sentence to two that would actually have a substantive effect. But I'm asking about this one.
I mean, there could be some editorial changes that aren't, but in Dudman Communications, this court talked about the importance.
Let me ask you about one other, just one other, okay? You see the sentence in there, similarly, in litigation, DOJ civil division lawyers are charged with advancing reasonable legal arguments. See that argument? That's suppose one of the earlier drafts didn't have that sentence. And the lawyer and the staff lawyer said, we really ought to add something that says that the civil division lawyers are charged with advancing reasonable legal arguments. I mean, is that deliberative? Isn't it a statement of fact?
It is, but in choosing which statements of fact to go into a document, it can be the type of editorial and deliberative judgment that implicates.
Agreed, but what about this one? Agreed, but what about this one?
I think it could, because that kind of sets the emphasis about the and recognition of the standard position, the kind of default that DOJ takes. But if I could make one point about differences, courts have recognized, we cited the Ninth Circuit case in Mobile versus EPA, that a draft doesn't have to actually differ from a final version in order to be deliberative. So when we're just looking at whether the privilege applies, we don't look at the kind of degree of difference over successive drafts. Now, this might be relevant certainly to the harm inquiry, but when we're talking about the privilege, the question is whether it was the final version that communicates the policy of the agency.
Yeah, I just have one more question. So we have two kind of major cases here that we can look to. One is Machado, and the other is Reporters Committee. And one went one way and one went the other way. So will you take a look, just tell me, take the Brinkman Declaration, for example. What's your best argument that they're more like the declarations in Machado, which were successful, and less like the ones in Reporters Committee, which were deficient?
So I think we have two reasons. One is Reporters Committee said that in the Machado declarations, it was boilerplate and generic assertions that the release of any deliberative material would chill internal discussions. And the flaw was that Hardy did not explain the particular sensitivity of the types of information at issue or the role they play in the decision process. Here in paragraph 77, it's specifically about public statements drafted by the Attorney General. So it satisfies the Machado standard.
Right. So that's really interesting. That's helpful to me because, so what you're saying here, because I compared the unsuccessful affidavit in Reporters Committee to the Brinkman affidavits here, and frankly, they're indistinguishable as far as I can tell, except for one factor, which you just put your finger on, which is here, these are drafts to the Attorney General. And so that brings us back to your earlier point, which is interesting. But I'm kind of wondering what the support for it is, which is basically the government's position here is that drafts of documents for the Attorney General of the United States are exemption 5 privileged, right?
Well,
that's your position.
This brings me to my second point, if I could.
But if I wrote an opinion and said the government argues that drafts of documents for the Attorney General are privileged by themselves, would that be accurate?
I don't think it would be any draft, but I think it could be a draft involving setting out the reasoning for this type of policy decision, yes. And to that point, Reporters Committee, in assessing emails concerning the director of FBI's letter to the editor of the New York Times, the court said the very context and purpose of those communications make the foreseeability of harm manifest. So I think that's another part of Reporters Committee
FOIA,
that compares
but
here.
now you're doing what you accused me of doing earlier. That's about the FOIA improvement, isn't it?
No, it is, but
Yeah.
so I was trying to get back to my second point, but even for the purpose, I mean, with respect to the privilege, I apologize. The court and Reporters Committee found those emails privileged, relying on, it said the privilege may extend to internal deliberations about how to promote or preserve an existing policy in the midst of public debate over whether the government should have such a policy. And I think that's comparable here. We have the executive order, and the Attorney General is deciding whether that will be defended or not, and how to communicate that both to the public and to members of the department that would implement that decision.
All right, Judge Tatel, any more questions?
No, thank you,
All
Judge.
right. Judge Wilkins, any question?
No.
Okay, then Madam Clerk, if you would give Mr. Orphanides the remainder of his time.
Thank you, Your Honor. In response to Judge Tatel's question about whether a request was made for in-camera review, I checked the record, and I did not see that by either party. There's just one other point I wanted to make about the difference between the Machado case or Omada and Reporters Committee. The documents at issue in the earlier case, Omada, were part of a regularized administrative process of adjudicating internal or administrative FOIA appeals. So I think the role that those documents played was well known, and that filled in some of the gaps that are missing in both Reporters Committee and in our case, where what you really have are sort of one-off. Reporters Committee being, a response to a draft OIG investigation and related items. Here, this is also it's sort of a one-off. So it was more of, in both our case and Reporters Committee, it's sort of like an ad hoc process. So without the additional information, without a more full description of what these records are, it's really not possible to either to make any conclusion about the deliberative process or especially the harm analysis.
But what we do know about the documents, what's obvious from the context and from the declarations, is that they are iterations of the articulation of the reasons for the policy decision that Acting Attorney General Yates ultimately gave to the public, right? We know that.
I wouldn't say that. My understanding is that the declarations are inconsistent. They describe it as a decision and they describe it as instructions to employees of the department. So
but the decision is an instruction to the employees of the department, which is that we're not going to defend this policy, right? It's not inconsistent.
I don't know if they're deliberating the decision or if they're deliberating how to instruct the department about the decision, which to me is crucial to perform.
Well, if they're deliberating the decision, it's pretty clear that they're deliberative, right?
I'm sorry?
If they're deliberating the decision, that's pretty clearly deliberative, correct?
I think it depends on the nature. Again, if they're moving sentences around or changing happy to glads or adding commas, fixing punctuation, I don't think that's necessarily deliberative.
Well, I guess the point I'm getting at is that to the extent that it appears evident that this is Acting Attorney General Yates both getting input in and editing her explanation for a policy decision that she's going to explain to both her staff and the people of the United States, why isn't that by its nature deliberative for the reasons that were discussed in the prior questioning between Judge Tatel and counsel for the government?
I think my answer would be the same, is that we need more information about the differences between the documents before we can make any kind of determination.
You're not answering my question. I told you assume that that's the nature of the discussion. Why isn't that by its nature deliberative?
It could be if one draft was we're going to enforce the executive order and the other draft was we're not going to enforce the executive order, and then there were some editorial changes. I mean, I could see how that could be deliberative, but we don't know the answer to that. I mean, I guess that's part of the assumption. The assumption.
If I'm writing an opinion and I move some words around and insert a citation or change a citation or break a paragraph into two parts because I want to emphasize a point and I don't want it to get buried in a paragraph. All of that is I mean, I've made a decision about what the outcome of the case is going to be, but all of this is all of these are changes about how I'm explaining that decision. Isn't that all deliberative?
No, I would say that's wordsmithing.
Okay.
But you don't have to prevail here. Couldn't you have answered Judge Wilkins just the opposite? Isn't your point that you don't know here?
That is right, but I think.
I mean,
my assumption is
why would you answer his question? I don't understand why you'd fight his hypothetical. I mean, it seems to me he's right that those kinds of substantive changes are clearly deliberative.
I think substantive changes are. That's correct.
Well, but even language changes can be substantive.
Can be, but it depends.
By where you put in only in a sentence can be substantive. Whether you use passive or active can be substantive. I thought your point was we don't know enough about these documents.
That's right, but I thought that the hypothetical assumed that we did, so I was being more careful.
Sorry. Okay.
All right. If there are no more questions, gentlemen, thank you. And Madam Clerk, if you'll call the last case.
Case number 20-7087, Cameroon Whiteru, individually and as personal representative of the estate of Okimutesi Whiteru and Agnes Whiteru, appellants, versus Washington Metropolitan Area Transit Authority. Ms. Graber for the appellants, Mr. Amir Thallingham for the appellee.
Ms. Graber, good morning.
Good morning, Your Honor, and may it please the court. In this case, the district court recognized that WMATA, like every common carrier, owes a duty to rescue its passengers, and WMATA does not contest that. The district court also recognized that the duty remained even when the passenger's own negligence caused the need for the rescue. And again, WMATA does not contest that. At page 43 of its brief, it concedes the duty. The district court's judgment and WMATA's brief rely only on the argument that a passenger's contributory negligence bars his recovery even when a common carrier has a duty to rescue him from the consequences of that negligence. That argument is directly contrary to Section 314A of the restatement, which the District of Columbia has adopted. It is contrary to a long line of common law, finding that contributory negligence is not a bar to recovery against common carriers who fail to fulfill their duty to rescue their injured or helpless passengers. And it is contrary to public policy and common sense in this case, where WMATA invited intoxicated passengers to use its late night services as a safer alternative for other means of getting home after a night out of the bars. Plaintiff does not dispute that Mr. Whiteru was negligent, but Mr. Whiteru's negligence ended when he fell and was paralyzed. and at that point, WMATA's duty to rescue him arose, regardless of the cause of his injuries. We have never disputed that WMATA may raise a contributory negligence defense in some cases, but not in cases claiming damages for the worsening of an injury after WMATA's duty to rescue a plaintiff from his own negligence arose. Indeed, it would be a peculiar rule of law that where a defendant's duty presupposes the plaintiff has been negligent, and where that duty requires the defendant to take care of the plaintiff because of his negligence, the plaintiff's negligence nevertheless bars their recovery. And that is not the law in the District of Columbia. WMATA has not disputed that the district follows Section 314A of the Second Restatement of Torts. And that section states that a common carrier has a duty to come to the aid of its injured passengers after it has reason to know that they are injured. The Court of Appeals has turned to Section 314A repeatedly to define the duties that WMATA owes to its passengers. There are a few cases cited on page 12 of our opening brief, WMATA versus O'Neill and McKethian versus WMATA. And additionally, since briefing in this case was completed, I'd like to draw the court's attention to a case in the federal district court that was another failure to rescue case, a slip and fall against WMATA, in which that court held that 314A of the Second Restatement has been relied upon by the DC Court of Appeals to determine the scope of WMATA's duties to its passengers. That case is Cobb versus WMATA, 2021 Westlaw 2935891, and it was decided in July. So under Section 314A, a passenger who negligently injures himself can recover from a common carrier for the worsening of the injuries if the common carrier negligently fails to render aid. Comment D.
The district court in WMATA here place a lot of reliance on the DC pattern jury instruction language and the Andrews v. Wilkins case from our court. Why was it? Why aren't those cases controlling here?
Your Honor, again, we have not contested that there are cases in which contributory negligence could bar a claim against WMATA, but the DC pattern jury instruction doesn't apply to a failure to rescue case, because in that kind of case, WMATA's duty presupposes that the plaintiff is in peril, and it takes into account that WMATA owes him a duty to rescue him from that peril. So the DC pattern jury instructions and cases cited by WMATA and the district court are only cases where the plaintiff and WMATA's negligence concurred in time to produce an initial injury. They don't involve instances where then there's a claim that WMATA failed to render aid after the injury. And I will get to your question about Andrews, but I just want to illustrate this point. If you take the case of WMATA versus Cross, for example, that was a case where an elderly woman fell backwards and hit her head when she was standing in the aisle when a WMATA bus moved. Now, in that case, even if a jury had found that the plaintiff had been negligent in standing while the bus moved, and even if the jury had gone on to find that WMATA was not negligent when the bus began to move, if the bus driver had just let Mrs. Cross lie in the aisle bleeding without rendering any assistance, Mrs. Cross would have had a claim for the aggravation of her injuries that resulted. Now, she didn't bring that claim, but WMATA's argument here is that she would not have been able to recover at all for that, and that's not the law. With regard to the Andrews case, in that case, this court did not determine that there was any duty for the police officers to rescue Mr. Andrews. In fact, they found the opposite with regard to the constitutional duty. They decided that there was no duty to rescue. And in the absence of that special relationship between the plaintiff and the defendant, there was no reason for the court to consider whether contributory negligence would bar the plaintiff from recovery. The fact that the officer's negligence was occurring during a rescue, again, in the absence of that relationship, was just a fact of the case. It wasn't a fact that had significant legal importance. But in this case, again, WMATA has never disputed.
And this, I get your point. Was there a dispute of fact below about whether the plaintiff's injuries were in fact aggravated by the alleged, breach of duty by WMATA?
There's certainly a dispute of fact regarding whether WMATA should have discovered Mr. Whiteru. I don't believe that there is a dispute of fact regarding that. Had Mr. Whiteru been discovered in a timely fashion during the normal inspection rounds that the WMATA station manager was required to make, he would have made a full recovery. There is a dispute of fact regarding whether or not the station manager made those rounds and whether she should have discovered Mr. Whiteru during those rounds. And the district court determined in its initial summary judgment opinion that could go to the jury.
But the district court, I thought, also determined that that plaintiff needed to have expert testimony about the national standard of care and whether that standard was breached here. But I guess that issue still needs to be litigated because the second summary judgment motion was granted before the district court reached that issue, or where did that end up?
Yes, Your Honor, that's right. The district court allowed the discovery to be reopened for the plaintiffs to name additional experts. WMATA has filed a motion in limine challenging those experts, to which the plaintiffs have responded, but it did not file for summary judgment on the basis that the experts were inadequate to establish the national standard of care, and the motion in limine was never ruled on. So that issue is not currently before the court. I do see that my time has up, and I want to make sure that I preserve time for rebuttal. So
we'll give you a couple of minutes if there are no questions. All right, thank you. Mr. Amarthalagam.
Good morning, Your Honor. May it please the court, my name is Nimi Amarthalagam. I represent the defendant, appellee WMATA. I think we can all agree that contributory negligence is the law in the District of Columbia. I think we can all agree that there's no statute or regulation or rule of law that would prevent the application of contributory negligence in this case. Plaintiff is arguing in this case that WMATA had a duty to aid Mr. Whiteru after his negligent act. However, plaintiff has admitted that they are not seeking the common exception to contributory negligence in those cases, which is the last clear chance doctrine. Plaintiff is also claiming that there's no negligent act by WMATA that caused Mr. Whiteru to—
Counsel, last clear chance is completely separate from the theory of recovery under restatement section 314A, correct?
I would disagree. The last clear chance doctrine is discussed later on in the restatement under the contributory negligence section, and the section that talks about, when contributory negligence cannot be applied. And I think the district court noted that in its ruling. This rule, section 314A, deals with duty, and that is a lot of what appellants have been discussing is duty, but contributory negligence deals with recovery. So as in the Evans case, WMATA was found negligent. The jury found WMATA negligent of running over Mr. Evans, but ruled that he could not recover because of the contributory negligence. And that ruling was affirmed by the DC Circuit.
But
so
that's wasn't a duty to rescue or a duty to render aid case. So that case is irrelevant.
Well, I think it's one and the same, because I think it's a duty to prevent harm to a person, whether it was Mr. Evans was in the road and to prevent.
Come on, counsel. There are two different things. Let's just, are you contesting that restatement section 314A is the law in the District of Columbia?
I'm not, I would agree with that. I think WMATA has a duty to aid people.
So the way that duty to aid operates then is that if WMATA has a duty to render aid, even if the plaintiff was negligent in causing the injury in the first place, and WMATA does not fulfill its duty to render aid, then WMATA can be liable for the aggravation of the injuries. That's what the restatement.
But in this case, I don't think there was an aggravation of the injury. The reasonable consequence.
Answer my question as to the law. Did I just state the law correctly?
I don't think 314A says that it's, I mean, I think a reading of 314A doesn't say that it encompasses the aggravation of injury. It says that the common carrier has a duty to the passenger to take reasonable action to give them aid and to take care of them until they can be cared for by others.
Judge Wilkins, we've lost your audio.
Thank you. I'm looking at the illustration 1 of restatement 314A. A passenger on the train of B railroad negligently falls off the train and is injured. The train crew discover that he has fallen off, but do nothing to send aid to him or to notify others to do so. A lies unconscious by the side of the track in a cold rain for several hours, as a result of which his original injuries are seriously aggravated. B railroad is subject to liability to A for the aggravation of his injuries.
Yes, I see that.
Isn't that the theory of liability here?
I understand the appellant's theory and I understand what you said, but I mean, that illustration 1, as the appellant said, came from the Yazoo case. And in that case, there was no contributory negligence found. And I think there is a difference between negligence and contributory negligence.
The illustration itself begins by saying a passenger on the train of B railroad negligently falls off the train. So the illustration itself, even if it was taken from the Yazoo case, the illustration assumes that the passenger was negligent.
I agree, but I do think there's a difference between negligence, committing a negligent act, and something that's contributory negligence, which is the proximate cause of your damages. I think there is a difference there.
Okay. I fail to see it, but continue your argument.
I've just before you begin, I fail to see it too. So what is the difference between negligence and contributory negligence, certainly under 314A? Well,
I think if you're a contributory negligent, there's been a determination that your actions are a proximate cause of your damages. And I think if you're just acting negligent and there's been no finding that negligence is the proximate cause of your damages, I think that's the difference.
Well, it depends, I guess, on when you're looking at the determination that someone was either negligent or contributorily negligent. Not just the allegation, but the finding.
Yeah.
Go ahead with your argument.
Yeah, and I mean, I think in Yazoo, which that illustration is based on, the court found that, I mean, it was a jury issue and the jury did not find contributory negligence, but the court found that the common carrier put the plaintiff in a position of peril by its actions of, the plaintiff could not sit inside the train. He had to sit outside by the side of the train. So I think it's a little bit different. But the plaintiff in this case is also not alleging any antecedent negligence on the part of WMATA in putting him in a position of peril. So the plaintiff is relying on out-of-state cases when there is DC case law that establishes that a passenger's contributory negligence can bar their claim. There's cases in DC. There's the Fells case, the Butler, and the McCallum case. And as the court has previously recognized, there is a DC jury instruction on it. And the Andrews case, I think, is particularly instructive. And there was a common law duty, negligent duty to aid claim in that case. And the court analyzed that by finding that the decedent was contributory negligent and that he could not recover because he cannot avail himself of the last clear chance doctrine. And I think the Evans case is also on point because that showed the court held that when the plaintiff was arguing that his antecedent negligence didn't matter, the court held, well, that's contrary to DC law.
But it wasn't a duty to render aid case.
I understand.
So you're telling me that if someone is on a WMATA bus and the bus driver tells them, please sit down, but they don't, and as a result, when the bus stops, the person falls down and hits their head, and the bus driver doesn't render any aid and doesn't allow anyone else to help the passenger, and assume for the hypothetical that the injuries are aggravated, that WMATA would not be liable. Is that your position?
No, because I think in that instance, contributory negligence doesn't apply if there's reckless indifference or gross negligence. I think if somebody had seen somebody that's injured, if a WMATA employee had seen a passenger that was injured and just disregarded them, I don't think they can use contributory negligence.
But there was contributory negligence by the plaintiff because the plaintiff didn't sit down when told to sit down, and their negligent act resulted in them falling and resulted in them becoming injured in the first place. That's contributory negligence by the plaintiff, right?
Yes, but I guess the distinction is that I'm trying to make is that if the bus driver just ignored him, that would be gross negligence or reckless indifference, and you can't apply contributory negligence as a defense in that instance.
Isn't that section restatement section 314A illustration 1, my hypothetical, isn't it the same as the application of the common carrier's duty to render aid because of the special relationship? That's the basis of the restatement.
Yeah, and the train operator in that case disregarded when other passengers were telling them that this person had fell over, and he said, well, we'll get him later. And they went, 3 or 4 stops later, and he had suffered more injuries.
So what's the difference between my hypothetical and the plaintiff's case here, Mr. Whiteru?
Well, I don't think there's any evidence that anybody deliberately ignored Mr. Whiteru or disregarded him after they had noticed him. There's no evidence in the case of that.
Well, we haven't gotten there yet, right? That's the whole point.
I agree. There is a motion to eliminate on the duty issue. But at this point, there is no evidence that somebody committed gross negligence or reckless indifference to Mr. Whiteru. And I think the appellant would agree with that. There is no evidence in the case. Discovery is over. The issue is remaining in the cases, was there a duty to look over the parapet wall into an area where passengers don't normally stand or wait for a train?
All right, thank you.
All right, Judge Tatel, do you have any question?
No.
Okay, all right, then, Madam Clerk, I believe Ms. Graber has some time left. No, but take 2 minutes.
Okay, thank you. I just wanted to refer the court to page 64 of the joint appendix about the aggravation of injury issue, in which shows that there is agreement between the parties that had Mr. Whiteru been discovered at 1:30 a.m., which was the time that the next inspection was supposed to take place after his fall, he would have survived his injuries. And so the Whiteru's argument is that the failure of the defendant to make a reasonable inspection of the station did lead directly to Mr. Whiteru's several hours of pain and suffering and to his death. And I'll just conclude by noting that I do think that the application and the admission by WMATA that 314A applies to this case resolves this case, because 314A makes clear that it's not only when the common carrier knows that its passengers are injured, but when it has reason to know that they are ill and injured, that it must take action to save them from the consequences of their own negligence. And that is the duty that WMATA violated here, and it cannot raise Mr. Whiteru's contributory negligence as a bar to his recovery. Thank you.
All right. Thank you, counsel. Madam Clerk, if you would adjourn court.
This honorable court is now adjourned until Thursday, September 23rd at 9:30 a.m.